We have the Judiciary Committee. We got, we're going to call the roll, but there's a few bills that I have been asked to carry over, which I'm certainly going to do so. Representative Hollis asked me to carry hers over, which is 54. Representative Brown, we're really going to amend Bill 228 to take care of some of Representative Brown's issues that he had. So we will carry over 126. We're going to carry over 264, 288, and 248 and 249. So we shouldn't have that that bad of agenda today, but perhaps next week we will make up for it. Who knows? All right, call the roll, Brandy. Let's go.
Hill.
Here.
Wadsworth. Here. England.
Here.
Bedsole. Brinyard. Chestnut. Faulkner.
Here.
McClammy. Pettis.
Here.
Robbins. Robertson. Simpson.
Here.
Starnes. Here. Stringer. Tillman. Here. We have a quorum.
Thank you. Representative Ingram, you ready?
Yes, sir, Chairman.
Thank you. This, folks, is House Bill 37. House Bill 37.
Yes, sir. Thank you, Chairman. Thank you, committee. This is a bill that we passed last year. It's been vetted a little different. We got it out of committee last year and got it to the floor, got it off of the floor, got held up in the Senate just because of it was late to the party. But we've changed it on your request, Mr. Chairman, on mandatory sentence, and we've taken out the 48 hours in hold, and we've taken out the minimum of 60 days, and we've made it to a Class D felony. And then only enhanced would be if a child under the age of 14 or when one of the offenders are on probation or parole or out on bail. And the statute is already in place if they hurt somebody in a wreck or kill somebody with a manslaughter, et cetera, under the existing law. And I do have a sub that I'm talking about is in the sub, and I think I have Representative Faulkner that's going to present that, Mr. Chairman.
Mr. Faulkner, go ahead.
Mr. Chairman, I would offer the substitute bill and make a motion for its adoption. And Representative Ingram can probably do a better job than me, so if there's any questions. But what the substitute bill, the additions, enhancements, and punishments, the difference is it's establishing and attempting to elude a law enforcement officer as a Class D felony, reclassifying eluding to a Class D felony would align the penalty with inherent danger of the act itself. Enhanced felony level Class C for children in the vehicle. Only charge as of now is reckless endangerment, a misdemeanor even if they're children in the vehicle. Imposing a Class C felony would protect minors and reflect the heightened culpability for each individual person under the age of 14 in a vehicle. Enhanced felony level Class C for eluding while on pretrial release. This holds those accountable who have been released on bond, bail, or pretrial diversion, recognizing the culpability of abusing court-granted liberty. Enhanced felony level Class C for one prior conviction of attempting to elude. Enhanced felony level Class B for attempting to strike a law enforcement officer. Imposing a Class B felony would send a message to our officers that we have their back and no longer tolerate attempted targets on their life. This mirrors other laws automatically upgraded when the victim is a law enforcement officer. And enhanced felony level Class B for 2 or more prior convictions of attempting to elude. That's the highlights, I believe, but Representative Ingram, it's your bill and your substitute.
That's correct.
I do offer it, Mr. Chairman, since we're discussing only the substitute, that we go ahead and adopt that.
That's right. Is there a second to adopt the sub? Is that what you do? Okay, there's a second. Mr. England has seconded. Now, are there any questions on the sub? I understand. Has anybody got any questions for Representative Ingram on the sub? All right, there's a motion for a favorable report. Okay, I'm sorry. All in favor of adopting the sub, my bad, say aye. Any opposed? See there, Brandy, that's why you sit right there, because you keep up with the procedural part of this, and that's important. So thank you. Thanks, Mr. Pettis. Mr. Pettis gives us a favorable report. Is there a second to that? Thank you. Favorable report and seconded. All in favor of giving the sub a favorable report, please say aye. Any opposed? Thank you, sir. Appreciate it.
Chairman, thank you. Appreciate you working with me on this.
You're
Thank
more
you.
than welcome. Mr. Estes, are you ready on 132?
Yes, Mr. Chairman, I am. Many of you will remember I was here last week and noted that lying in the bed the night before I was to appear before the committee, that I really didn't think we had really laser focused this quite well enough. So you sent it to subcommittee, and we met yesterday and had some, obviously, attorneys working in the room with me. That was of great benefit to me. And I have an amendment to bring as part of HB 132 today, I think, that will clarify.
Are you going to bring the amendment,
Our
Mr.
concerns.
Estes, or somebody else? Okay. Mr. Simpson, how about let's do the amendment, okay?
The amendment should be in your packet. It's to replace line 100 on page 4 with the following. Environment as defined in section 1622A, section sub 3. He or she is 1, at least 19 years of age, 2, is not employed by or enrolled in the entity associated with the educational environment as defined in section 1622A3, and 3 causes.
Okay.
With that, Mr. Chairman, I move for the adoption of the amendment.
All right, second. The amendment has been offered and seconded. Is there any questions concerning the amendment? Seeing none, all in favor of adopting the amendment, please say aye. Aye. All right, any opposed? So, Mr. Estes, it is back to you as amended.
Thank you, Mr. Chairman. Again, I'll reiterate quickly what we discussed last week. This is not we're just adding to an existing code a class of persons that would be protected from serious bodily injury. We're including our students in that. We know we've done it for postal workers before, human rights, DHR employees, teachers, and things of that nature. So we just had an incident that drew this to my attention in my district. We had two young men get in a fight at school, and the father of the boy that allegedly lost the fight showed up to see the principal the next day, and as he was beat through security, he walked in, and the young man that had won the fight, so to say, walked out in the hallway, and the father took exception to what had happened and threw him up against the lockers and things of that nature. So what we did with that amendment, we just wanted to narrow the scope that if we have two guys or girls getting in a fight on campus or in a locker room or anything like that, we believe the principal and the school board and the superintendent can handle those things locally, and it keeps it from going into juvenile justice system, lightens their load a little bit, and just make sure that we were accomplishing with this bill what we wanted to do, Mr. Chairman.
We appreciate it. All right. Is there a motion to adopt or give a favorable report as amended? Do I hear a second? Second. Thank you. Motion and seconded. Is there any more questions for Mr. Estes? Seeing none, all in favor of a favorable report as amended, please say aye. Any opposed? Mr. Estes, thanks a lot. We
Thank you,
appreciate
Mr. Chairman and
very
body.
much. Mr. Yarbrough, House Bill 13.
Thank you, Mr. Chairman, members of the committee. This is the same bill that we passed out last year, so I think we all looked over it and read it and had a public hearing, and so I would ask for a favorable report.
Any questions for Mr. Estes? Yes, sir. Mr. Ingram, please.
Representative Yarbrough, how do you imagine or envision this working?
Well, similar to this bill was drafted and as a replica, more or less, from Georgia, who passed this legislation. And so, the situation there that tragically cost the life of the young lady after whom the bill is named, the person who took her life had committed several crimes up to that point, and he had been released multiple times, and there had been no working with law enforcement and the federal government as far as immigration status. So, the situation that birthed this bill the goal there was to provide a way for someone who's not here legally, who's committing crimes, to be removed from the country so they can't commit crimes.
So how do you envision it happening practically?
In the commission of a crime, that is, again, similar to the case that caused this bill. They would have had an MOU set up where they would have been able to check with the federal government on that person's immigration status because that person had committed crimes, to see if this is someone that they want in their community.
So, I mean, how do you envision enforcement of this happening on a local level?
Someone commits a crime.
So is that what your bill says?
I mean, I know we had this discussion in the public hearing about probable cause, and the fact that the bill, probable cause requires a crime, and the bill prohibits anyone from being detained on the basis of them being here illegally. So,
Are you familiar with Kavanaugh stops?
I've heard the phrase, but you can remind me.
To stop an individual for brief questioning about immigration status, the government must have reasonable suspicion that the individual is illegally present in the United States. Whether an officer has reasonable suspicion depends on the totality of circumstances. Here, those circumstances include that there is an extremely high number and percentage of illegal immigrants in the Los Angeles area, that those individuals tend to gather in certain locations to seek daily work, that those individuals often work in certain kinds of jobs, such as day labor, landscaping, agriculture, and construction, and that many of those illegally in the Los Angeles area come from Mexico or Central America and do not speak much English. To be clear, apparent ethnicity alone cannot furnish reasonable suspicion under this court's case law regarding immigration stops. However, it can be a relevant factor when considered along with other salient factors. So what does that become in an analysis of whether or not somebody is stopped or detained to determine their immigration status?
Well, again, probable cause, you're not allowed to just stop someone because they look different than you.
Not talking about probable cause.
But that's what the bill says is probable cause. The bill doesn't talk about reasonable suspicion.
Reasonable suspicion is before probable cause.
It's a lower bar.
Yes. So these are steps we get to probable cause. Based on the language of the Kavanaugh, from Justice Kavanaugh, he's authorized, to some people's opinion, and obviously in our Border Patrol and ICE agents, has authorized them to use in their pursuit of undocumented citizens things like jobs, the fact that they don't speak English, where they are, those sorts of things that directly lead to stopping someone because of their ethnicity. Because obviously, if we read the description and what this dicta has become across the country, it's become the basis of what's called Kavanaugh stops, like Terry stops, Kavanaugh stops. So essentially, it encourages law enforcement officers when they're on the scene to determine if somebody's here without documentation, to engage in the sort of racial profiling that history has told us has generally been deemed unconstitutional. Your bill goes out of its way to say that we can't necessarily stop you just because of your ethnicity. Now, does your bill also require a federal agent to be present if the MOU has been reached between a local agency and a federal agency? Does it require the federal agent to be present in order for that local law enforcement officer to become a de facto immigration officer?
It does not.
So they could do this without federal agents there.
They have to follow the guidelines of the MOU that they established with the federal government.
The MOU follows what Supreme Court has said, what federal law has said. Is that correct?
They would have to follow the MOU that they established with the federal government.
Right. So if the federal government's current practices mirror what the Supreme Court has ordered, which again across the country that's what brought this lawsuit on initially, is because several organizations sued the United States of America in terms of how this is going to be enforced. And Justice Kavanaugh opened up a very wide door in how federal agents are to do immigration enforcement, which essentially turns an eye towards individuals who gather to day laborers who gather in the same place who don't speak English. That can become in the totality of the circumstances, that could become part of the reason that individual is detained. So if that's part of how this thing flows from the Supreme Court to federal agencies to MOUs that reflect the policy of Homeland Security and so forth, and that MOU marries that, it uses the same language, it seems to me that if we follow that all the way down, what we're encouraging or allowing our officers to do in this situation is to basically look at somebody, profile them because of where they're getting their employment from, and also how they don't speak English, as Kavanaugh said in his opinion, that they can be detained at that point. Would you agree?
They have to follow not only probable cause, the MOU, and this is why we also accepted the amendment of his last session or session before from across the aisle at the end of the bill that says that nothing in this act shall limit or abridge any right created or recognized by the Constitution of Alabama or the U.S. Constitution. So we put multiple safeguards in here. And again, to your original question of how we envision this operating, again, the whole context of this and the envisionment is just like what happened for the namesake of the lady who lost her life.
Mm-hmm. And I get that. What I'm concerned about is that we're going to allow local law enforcement to engage in a practice that is currently authorized by Supreme Court logic that will cause some of our local law enforcement agents to get involved in racial profiling and asking for things that they wouldn't normally ask an American citizen for. Generally speaking, if you speak English or white, the benefit of the doubt follows you. But if you aren't, the presumption follows you that you're not here legally because you don't speak English or you're looking for day labor and so forth, that then leads to uneven enforcement. And I'm also concerned that because you don't have to have a federal agent with you, what normally happens in these situations is when you determine whether or not somebody gets detained, the amount of time that detention is allowed to legally and unconstitutionally occur is related to the initial reason for the stop. If the stop continues to extend beyond the initial reason for the stop without any sort of other suspicion or circumstance, then you start wavering into unconstitutional territory. Since we are local law enforcement officers who don't have access to all of the federal rules, regulations, paperwork, because you wouldn't be able to look on the side of the street and determine if somebody's here on a student visa, a work visa, or some other reason that gets them here legally where they don't have the quintessential American citizenship documentation, right? So what that means is that detention of that individual, as you pursue that information, it's not likely going to be readily available to you, will again extend well beyond the reason for the stop. And also, let's not forget, being here undocumented for some people is a crime, right?
It can be, yeah.
Yes, it can be. So it becomes another reason to detain. So it's not necessarily, as we've seen across the country, people who've committed violent offenses and violent criminals that we all want out because of the unintended consequences of the language of that from the Supreme Court justice. Now many people who are here, legal American citizens, their rights are being trampled on in pursuit of people who are not here legally. So what I'm concerned about is without the federal government being involved, and it's just two local law enforcement agents or whoever we have, if something happens, we don't get the same protection that those federal agents would get. What we end up with on cities and counties is a different standard, more exposure to liability, because eventually when this immigration house of cards falls, because it's really on very shaky ground as it speaks, because at this point, even Justice Kavanaugh is trying to back out of what he thinks he created, that we're all going to be left with these lawsuits involving a ton of civil rights violations that we can't defend. So in essence, I don't think we need to enter as local law enforcement agencies to enter into agreements on our own without somebody else intervening, which what the current law is with the Attorney General, right?
That's correct.
So I think it makes more sense, it'd be more prudent on us to allow that level of scrutiny to continue to exist to make sure that somebody beyond just that local law enforcement agency makes the determination of whether or not our group of folks want to become de facto ICE agents, especially considering with situations like Renee Good, Alex Pretty, and the things that have happened in the rest of the country, even moving away from some of the things that have happened across the country, that it would make more sense for us to be as prudent and careful in how we approach this as not allowing certain things like this to happen. I don't think we're ready for it. I don't think many law enforcement officers today would want the ability to go out and start asking questions about, you know, where are you from, your ethnicity, you don't speak good English, why are you here, are you trying to get what are you working for, where you headed, who you're with. That sort of inquiry is something that we have been uncomfortable with for years. And the very last thing is most American citizens don't carry passports. They don't carry things that justify or substantiate their American citizenship. But with unequal and uneven enforcement, it turns into second-class citizenship almost, where certain people have to carry documentation that other Americans don't. And the Constitution itself exists so everybody gets treated the same under the law. Hell, even people who are here undocumented have the protection of due process. So, again, I don't think it's a good idea for us to have our local agencies entering into agreements outside of any other level of scrutiny because of a level of liability that we can impose on ourselves in the event a lot of this stuff goes away. So, I mean, that's my position on the bill. I'm not misunderstanding your position because what happened to Ms. Riley is a tragedy.
Sure.
But I do not want to trample over American citizens and the rights that we have. First Amendment, Second Amendment, Fourth Amendment from search and seizure and so forth to be trampled on as unintended consequences and collateral damage in pursuit of something that can be actually worked out in a very humane way.
Thank you. Simpson, I got you next.
I want to draw everyone's attention in the committee to line 102, the very last letter of line 102 and beginning into line 103. A law enforcement officer acting within the scope of his or her authority under any memorandum of understanding, agreement, or other authorization from the federal government may arrest with probable cause any individual suspected of being an illegal alien. Kavanaugh stops and detains have nothing to do with this memorandum because this memorandum would have to require the law enforcement officer to have probable cause under the language of your bill for the memorandum of understanding. Probable cause is a higher burden. It is a different level. It is a larger threshold. It is a much more difficult threshold than it is for a reasonable suspicion. And that's why everybody wants to talk about reasonable suspicion and try to conflate your bill and say your bill's about reasonable suspicion. Your bill is not about reasonable suspicion. Your bill is about probable cause and an agreement with local law enforcement to work with federal law enforcement where there is probable cause that a crime has been committed to help federal law enforcement. It has nothing to do with Kavanaugh stops or reasonable suspicion. And that's important, and that is a large distinction that I want to bring to your attention because in the committee's attention, because that is not what anybody has discussed in the public hearing or in this committees today.
Mr. Simpson, Mr. Potter, do you have something? I'm gonna get back.
Mr. Yarbrough.
Yes, sir.
I know you and I talked. There was a gentleman here that spoke at the last hearing, and you and I have talked about it. He reached out to me, and his name was Kevin Thomas, and he spoke about the fear he had of his daughter, American citizen, being detained, and that seemed to me to be the theme of the speakers who were here. And you know, as I said last week, and say again, and we've talked about this, we don't want that. We do not want American citizens You don't. I know that's not why you're bringing this bill. You don't want American citizens detained when they shouldn't be.
That's right.
And you certainly don't want them detained just because of how they look.
That's right.
Or if they're of Hispanic descent. And I know I don't want that, and I don't think any of my colleagues in the legislature want that. But, you know, one of the things, so I asked, you know, I was asking what is the language in the bill that we thought was giving the speakers, you know, what was creating their fear? What was the language in the bill, the specific language? One of the things he wrote me about and that you and I have discussed was this translator.
Right.
And you actually said something to me that you thought might be a beneficial change to that language. And for members of the committee, I'm talking about on lines 154 through 157, because it says an interpreter may be brought in to assist with the booking, you know, and I think you said, you know, law enforcement's concerned that if it's shall, and they don't have the ability to have an interpreter, how do we, you know, in reality, how does that work? And so I'm sensitive to that because I imagine there's a lot of, maybe there's departments that aren't going to have that. But, you know, I think you had something that you thought might work, and I'm not putting you on the spot. I don't know if you've got anything drafted, but I know my point is to the speakers that were here, you've been willing to work and listen to concerns.
That's right.
And if you can make something better in this bill, you're willing to do that. I do see this bill as more about just asking for cooperation and not changing. When you read the language of the bill, I know there's a lot of people that are upset with, you know, what we've seen that around the country, particularly Minnesota with ICE and this type of thing. But the language of this bill seems to me to be more about cooperation and not lessening the standard, not lessening constitutional law, not making it easier to trample on someone's rights. I don't see that in your bill. I mean, except if somebody wants to argue that simply by having local law enforcement cooperating, that's their objection to the bill. But I do see a lot of protections in this bill, and I appreciate your willingness, and I brought the concerns that this gentleman sent to me, and I've given those to you, and your willingness to work with people. If there's something language in this bill that we can make, so because nobody wants to see anybody's rights trampled on, nobody wants to see people detained simply because of how they look.
That's right.
You know, you don't want that. I know none of my colleagues want it. So. Anyway, that's my 2 cents on it. I do appreciate you looking at those comments that gentleman sent me, and if you know there's something to be done on that to you know lessen detention time by bringing in an interpreter, hope you'll consider that.
No, I would be happy to commit to work with you. I would love to have a favorable report today, but I'll be happy to work with you and discuss this. And I've taken several amendments throughout this process from both sides of the aisle. So I'm very willing to work with everyone.
Okay. Mr. Stringer, did you have a question or either question or comment? Either one. Go ahead.
Yes, sir. Is your bill going to force any of these agencies to work with the feds?
It will not. It's all voluntary.
It's just an agreement that allows them to work with the federal agencies.
That's right.
To do this.
That's right.
And is your bill going to limit the liability of officers if they do criminal acts or profile or do any unconstitutional?
No, they're held to the same standard of what their role in their office requires as now.
And that's what I read into the bill.
That's
So
right.
at the appropriate time, I'd like to give the bill a favorable report.
Okay. Mr. England, I had you down wanting another comment, please.
I just want to respond. Because I think I may be missing something, but I just want to reiterate. Reasonable suspicion is required before you get to probable cause. Reasonable suspicion is part of your initial investigation. Reasonable suspicion is the reason, the foundation that ultimately becomes the probable cause if the reasonable suspicion threshold is initially met. We don't walk up to somebody and just say, you're under arrest, here's probable cause. What we do is, hey, there are a series of reasons out there that make me suspicious, and we call it reasonable because of the person in the perspective of what I see. We put it in context to create what could eventually become probable cause. What the Supreme Court has said is that the reasonable suspicion when it comes to immigration expands what would normally not be considered as reasonable suspicion because of constitutional protections for everyone. In immigration stops, it opens the door for those initial things because that's part of the reasonable suspicion of you being here illegally. Part of that analysis now includes, from the Supreme Court decision, things like your speaking English, your appearance, what you're doing here. Are you, because he said it's, these folks engage in this practice to get these day jobs. All those things now become reasonable suspicion, which are associated with ethnicity. So we are essentially, through those stops, creating that reasonable suspicion using those initial and those things that used to be not allowed to be used. That's just a really simple, that's really simple. That's how we got here. That's what they sued for. And we couldn't use, because we didn't want people using that as reasonable suspicion. So when you talk about a local police officer through a memorandum of understanding who adopts those practices because the Supreme Court has, through that language, has allowed for that to happen, then you get to the point where I get to the illegal alien status because, hey, initially when I talked to you, you didn't speak very good English. You were congregated on the corner waiting for somebody to pick you up and go do whatever. So again, that's my pause here, and I think that's why people are afraid, because that reasoning, that logic, that Supreme Court opinion that's out there has given everybody the impression, rightfully or wrongfully, but mostly rightfully, that you can be profiled because of your skin color, the fact that you don't speak English, and so forth and so on, which then ultimately leads to people who are American citizens who are no longer carrying that benefit of the doubt anymore because they may get involved with law enforcement and they may exhibit some of these factors and end up being detained. That means that now normal American citizens who wouldn't normally have to carry documents like passports and things like that to prove American citizenship now have to. We have unequal and uneven enforcement that's created by the Supreme Court decision. And again, even he is trying to back away from it because of some of the chaos it's created and caused. So again, my pause in this legislation and why I don't think it's necessary. And honestly, I think we should be going the exact opposite direction as the country's temperature goes down and we're starting to reevaluate the impact of some of the things that we've done, not just in Minnesota, Minneapolis, but other places across the country, is to actually take our time and look at this legislation to see if other protections need to be installed in it to afford more protection for the average citizen who's becoming collateral damage in this enforcement action. And listen, you and I talked about this last year. There were some amendments made as a result of our conversations, and I really appreciate you being willing to work. But in my opinion, because of things that have happened and things that have been exposed, some of those fault lines, I think we need to sit down and have more conversation about this legislation, maybe adding some amendments to afford additional protections so people don't feel like second-class citizens and are afraid when law enforcement approaches them because they don't know if they're going to start asking questions that lead to inquiries about if there's immigration status, which then will lead to them being detained for no reason.
Mr. Simpson, you had a question or a comment?
Does your bill allow people to be arrested for reasonable suspicion?
No.
Does your bill allow for the local law enforcement to work with the federal agencies for reasonable suspicion?
No.
Thank you. No, it says probable cause. It doesn't.
All right, Ms. McClammy, I think you're next. Thank you for waiting.
Oh, thank you. I just have two questions. One is concerning local law enforcement. What does that encompass?
Well, you state and local law enforcement, so you've got obviously state officers and, sheriffs, local police.
I guess I would be questioning on college campuses, does that include campus security?
I mean, whatever follows all under the umbrella of, I mean, if they hire private security versus, local law enforcement, I assume it's different,
Would private security companies be included in this?
It's, I don't know if I wouldn't think so, no ma'am, because I don't know if it's local law enforcement, that's a private, we had private security like it where I worked at Nucor. That wasn't considered at all local law enforcement.
Okay, so once again, I go back to campus police. You would think that would be considered as private law enforcement?
I mean, it may depend on what the school has contracted. If the school contracts with local law enforcement,
I just have a concern about campus police, local law enforcement on campuses, stopping students that may be there from other countries with visas and just identifying them as they walk across campus and stopping them and holding them for those type of things.
Well, under this bill, if there's not probable cause, there's no reason for them to engage.
A second concern here is the fiscal note. I'm always looking out for taxpayers' money. And so it shows that it could increase the obligations of state and local law enforcement agencies by an undetermined amount depending on the cost to comply with certain booking and intake procedures of illegal aliens and foreign nationals established by this bill, and to public a report on certain jail data. Further, this bill could increase the administrative obligations of the Alabama Law Enforcement Agency to post reports of each jail on its website. This bill could increase the obligations of Office of Attorney General by requiring the Attorney General to report violations by officials or agencies to the governor. So do you have any type of estimate in your mind of how much additional funding would be made to these agencies if they do proceed to act as ICE agents, basically?
So this relates to two amendments that we already took, I believe it was last year. So we worked with ALEA because they already have to submit an annual report. So there's no, I mean, other than them putting it on the website. So ALEA was very happy with that to make it an annual report. And then we also took an amendment that said that the local law enforcement may report it, put it on the website, because some of them may not have websites or so forth. So, that local component of reporting is optional. And then if they do report, then it would go in the annual report to ALEA that they already submit. So we on both those fronts, we worked with local law enforcement and ALEA and took amendments for that.
So this is an old fiscal note that's dated 1/20? You've had amendments since then?
It was a year before. Whenever we added, we've had this, is it third time? Second time, but this fiscal note is for this bill, but again, for the reporting, we took amendments to work with local law enforcement and ALEA, so they were happy with it.
So this fiscal note needs to be updated because this is 1/20/26.
Well, those amendments were added last year.
Okay, so the fiscal note needs to be updated to show that, evidently. Thank you.
Okay, Mr. Stringer, did you make a motion for a favorable report? Am I correct? All right, is there a second to that? All right, there's a second. Is there any further comment or questions for Mr. Yarbrough? Okay, seeing none, all in favor of giving this bill a favorable report, please say aye. Any opposed? No. I understand. And Mr. Yarbrough, you get a favorable report. Thank you, sir. Appreciate it.
Thank you, sir. Thank you, members of the committee.
House Bill 7.
Thank you, Chairman, members of the committee. I'm bringing this here for Representative Matt Woods, who no longer exists. He's now in the Senate, but he had pre-filed this bill before his election to the Senate. So unique little footnote there in part of a great bill. So this bill passed this committee last year unanimously. It passed the House floor unanimously. It increases the penalties for terrorist threats upon our schools. There's a sub that actually extends that to other public places such as hospitals, nursing homes, anywhere where people are hunkered down. And look, the reason I was happy to carry this on behalf of Senator Woods is because this is taking place in my district where you have a credible threat that's made against a school. And, it causes a lot of issues for those children. Elementary school students are having to be treated for their mental health because they're scared to go to school. This creates a scenario where we now have a way we can put in some remedies there. It does 4 simple things, and it increases the penalties. It requires a school administrator, being a principal, to immediately alert the law enforcement if there is a credible threat made against a school. It forces a removal of a student if it is deemed a credible threat for a certain duration of time, so that they can have a mental health evaluation. And then finally, it does introduce restitution. It costs a lot of money for law enforcement to respond to these situations. You have lost class time, you have a lot of staff, you've got EMA professionals involved in this. So there is a penalty of up to $10,000. It is capped. But if there is real costs incurred in responding to that threat, then the parents of that student are on the hook for that. So it puts some real teeth, so that kids think twice about, and parents are educating their students about these things as well. So,
Mr. Chairman, do we have a sub?
there's a sub at the appropriate time.
I'd move for the adoption of the sub.
There's a motion and a second to adopt the sub. All in favor say aye.
Aye.
Opposed?
Mr. Chairman, I'd move for a favorable report as substituted.
Is there a second to that? All right, Mr. Stringer gives us a second. There's a motion, second, to give Mr. Lomax we have the substitute carrier for the substitute bill for the individual who's no longer a member of the House of Representatives. This has got to go down in the annals of what we do here, but we appreciate you doing it. We do.
Yeah.
So there's a motion and a second to give the sub a favorable report. All in favor say aye.
Aye.
Any opposed? Thank you, sir. Mr. Lomax.
Thank you.
thanks a lot. We appreciate you. Mr. Baker, you ready? You got 2. You got 188 and you've got 189. So let's just do them one at a time.
Will do. Thank you so much, Mr. Chairman, members of the committee. Each of the bills, which I'll, of course, handle them separately, were bills that came before this committee last year, did pass out of this committee, bring these bills back in the same form as last year. The first of the bills is somewhat similar to the bill that came just before, which at that time then former Representative Matt Woods, and then now Senator Woods. This involves then terrorist threats, particularly although it doesn't specify in regards to schools, but it has become more problematic with the schools and increasing in number, the number of threats that have been made against schools. The thing that I'd like to point out first and foremost, and then I'll somewhat separate, while this bill that I have is different, although similar, but yet very different from the bill that just came before you just now. Whenever there might be a threat to a school, and most of these threats to the schools generally are call-in threats. They could come otherwise. It could be where students scribbling down and whatever, and such as a gun, or it could be a bomb or whatever, and such. So it could be by other means, but more often than not, generally these would be call-in threats. A lot of people think, well, that's just kids just being mischievous. It's not treated as such. In today's time and age, particularly with events like active shooters, anytime that there's a threat that's called into a school, it's where it really then terrorizes somewhat much of the community, parents, the students, until they know otherwise. It must be treated as a credible threat. It's not as if, well, it's just a kid. Well, it may take them a day, 2 days, 3 days, a week to figure out exactly where that threat originated. That's a problem. Education has been compromised. You're talking about even if they identify once let's say it's a bomb threat that's been called into the school. Could be by a student that actually is attending school. It could be by a student from another school. It could be a student that has graduated from school already. They're in their late teens perhaps, and then they decide it's just something that's sort of a fun thing to do, or they actually have friends at that school and they actually sort of challenge them, hey, call in this. They may have a upcoming term paper due and they think this is an opportunity then, okay, I have more time to work on that. Whatever it might would be, and we think, well, it's just kids being kids. But the problem is now law enforcement has to get involved, the school officials have to get involved, and it may be that, that thereafter, even if they identify the day of or the second day after an event has occurred, many parents will still keep their kids out of school a little bit out of fear, thinking, oh, I'm not ready. Let's give it more time. This is a problem. But here's the issue. Under current law, so what this bill deals with, and so if you've got the bill before you, what the bill does not deal with is terrorist threat in the first degree. And that's most of what the bill is. That is through page 4. Once you get to page 5, it deals with terrorist threat in the second degree. And that's what I'm addressing. Terrorist threat in the second degree, in which with this would be a Class A misdemeanor. That will not change under my bill. We'll still keep it a Class A misdemeanor. So the issue is that district attorneys, there have been problems. This actually originated somewhat down in Baldwin County, but I think there's been some other similar areas across the state that might have also had somewhat very similar situations as what occurred in Baldwin County. And that would be that based on current law, a terrorist threat in the second degree must be proven to be credible and imminent. So that kid that was just being mischievous, the prosecutor doesn't really have basis to go ahead and proceed with the prosecution because it was not actually credible and something that was determined that could be executed, leaving the DA then powerless somewhat to even bring any type of charges, even a misdemeanor. So what this bill does, this removes the language for a terrorist threat in the second degree, removes credible and imminent from that. It does not change any of the current penalty, keeps that the same. It just removes credible and imminent. Now, there still is discretion within the district attorney's office, whether on any type of threat to the school, to make that determination whether to proceed with charges. So I want you to be aware of that. But this does at least allow now a basis going forward for where schools have been seriously hampered. Law enforcement has used resources, that is trying to scour the campus and then make a determination as to when they might go ahead and move forward with feeling more secure than to allow students back in the classrooms, and then any of the subsequent aftermath that I've already described that could occur even a few days thereafter. So with that, I'll be glad to entertain any questions on that. This is basically the same bill, but I did want to really highlight the significance. Then kids will be kids, I understand that, but the huge cost, the impact to schools, and education being compromised, particularly when we've got several days that school is not going on as it normally was prior to that threat then coming into the school.
Mr. Chairman?
Yes, sir.
I'd like to make a motion for a favorable report.
Second.
There we go.
I've got a question.
Okay, hang on. We got a motion and a second for a favorable report. Now, questions. Who we got? Mr. Robbins, go ahead.
Sure. I was reading the bill and had two quick questions. I was kind of wondering on page 4 on line 112 where I kind of wondered why you used the word sustained fear, where it says the statement causes the person to reasonably be in sustained fear for his or her own safety or for the object of the threat. Wouldn't we just say the person to reasonably be in fear? Because then you have to prove that they were in a sustained state of fear as opposed to just being placed in fear. And I'm not sure, how you'd prove that they were in sustained fear.
And this is on which line?
Line 112. I'm just thinking that my thought is if you're trying to prove the person, you're saying the statement causes the person to reasonably be in sustained fear for his or her own safety or for the object of the threat, that using that word sustained there, I'll say the David Faulkner thing. I don't practice criminal law, but I'm just thinking, what does sustained mean? And would it not, because basically what you're saying is it puts that person in a state of fear, but adding that word sustained adds this other burden that they had to stay in a state of fear and for how long. So just saying they were placed in a state of fear would probably be better.
All right, hang on. You will offer an amendment. So is, here, you want to offer that one?
I mean, well, I guess, do you have a question?
No. I much appreciate your diligence in scouring the bill and trying to find, I mean, to make it a better bill. So, no, I consider that would be a friendly amendment if that's the wish of this body.
So the amendment would simply be to remove the word sustained on line 112, right?
Correct.
Okay. Is there a second to that? All right, now, Mr. Baker, back to you. Do you have anything to say about that?
No, I consider that a friendly amendment then that would perhaps make the bill a better bill.
All right. I'm gonna let you, Mr. Tillman. Do you want to speak on the amendment, Mr. Tillman?
No.
Okay. All in favor of amending the bill to remove the word sustained, please say aye. Aye. Any opposed? Okay, Mr. Tillman, now I'm back to you with whatever.
We're pretty much on the same page, Representative Baker. On 109, a gravity of purpose. What do you mean by that? Is there a legal definition of that?
Once again, I did not so much prepare the language. This was done from legal bodies and those that had then, I guess, bites at the apple, so to speak. So I really could not give you a rationale behind that wording, gravity of purpose on
Okay.
that. I would be glad to allow, which we have a number of attorneys that's part of this illustrious then committee. I'd be glad for any of them to give their opinions in regards to that.
Yeah, because it'd be kind of similar to what Representative Robbins was saying with the sustain. So you're saying a gravity of purpose. So how would you prove that? How would you be able to say that in court that it was a gravity of purpose of a threat? So it's kind of vague from that standpoint.
No. Well, so what would you propose?
Yeah, either strike it completely or just say immediate perspective of execution of a threat.
I don't want to interrupt. I don't want to help you. The purpose should stay in because you can't just make it because if you take out the gravity of purpose and it says and an immediate prospect therein, then it only applies if there's an immediate prospect therein. So if you I agree with you completely if you take out the word of gravity, but maybe leave the word purpose in.
I can agree with that. Yeah.
What line are y'all on?
On 109.
Thank you. Okay, so Ray, you got that? Looks like we want to remove the word gravity.
Gravity of? Yeah, gravity of.
Gravity of, 2 words.
Mm-hmm.
Mr. Tillman, are you going to offer that amendment to remove to just simply on line 109 to remove the words gravity of? Okay. Number 2, right.
I will offer amendment number 2 to remove the words gravity of.
Thanks, Mr. Tillman. Is there a second? All in favor of adopting that amendment, please say aye.
Aye.
All right, now, are you okay with this? I should ask you, Mr. Baker, are you okay with that?
Mr. Chairman.
I sort of got for what you were saying you were, but I want to ask you.
Thank you so much, Mr. Chairman. Yeah, this is part of the sausage-making process. So once again, I very much welcome anything that strengthens or makes this a better bill. So once again, Representative Tillman, thank you so much for that, as well as Representative Robbins. Thank you for trying to add to the bill, make it a better bill. Thank you.
All right, so wait, before you take off, is there a motion to give the bill as amended twice a favorable report? And Mr. Simpson makes that, and okay, we're good. Any other comment about the bill or question? All in favor of giving the bill a favorable report as amended 2 times, please say aye. Any opposed? Thank you. Mr. Baker, appreciate it. Now, you're warmed up.
I'm warmed up and ready.
You're warmed up, Mr. Baker. Let's go to 189.
Thank you so much. Members of the committee, this is a bill that I had before you last year as well that did move out of this body. This is in regards to the juvenile courts and school notification. This is a very delicate, a very sensitive issue. Trying to find the right balance is something that I think is the goal of this bill. Currently, there's no requirement that schools be notified when there has been a juvenile delinquency, regardless of the extent of the crime, whether it be a very serious crime or less serious. And so it is something that's begun to surface. Yes, excuse me.
Mr. Chairman,
Sir,
make a motion for a favorable report.
wait a minute. Okay, there's a motion. Is there a second? Second. All right, now, Ms. McClammy, did you have a question and or comment?
I have a comment.
Okay.
We spoke about this, and I do have
Certainly.
one concern with this legislation is because currently it does have to be reported if there's capital offenses such as murder, first-degree rape, and first-degree sodomy. But I do have a concern because when a juvenile enters into the juvenile system, they have a right to have their records sealed. And with this piece of legislation, before they're even gone through the court process, if they're just charged with something, that this bill allows the judge to inform just not only superintendents, but principals, teachers, counselors. And when I practice in juvenile court, one thing that we usually tell parents and others that may be involved is that they cannot even tell their family members that a child has been in juvenile court because, as Coach Saban said today, you know, we make mistakes as children, and you have a right to a second chance.
Right.
And that could be those here today that been through juvenile court, and because of the protection of the state to have sealed records, they were able to have prosperous careers later on. And so I do have a concern about releasing information to that extent when they haven't even gone before a judge. They're just charged with a crime. And then it's disseminated to so many people, teachers, counselors. And I know we say, hey, don't tell anybody, but is that realistic? And so that is a question, concern I have with this law.
If I may respond, Mr. Chairman?
Sure.
You know, thank you so much, and thank you so much for the dialogue, the discussion that we got to have
That's right,
this
we talked
weekend. So I
about
much
this the other day.
appreciate that, I mean, and your interest in this. I would state that I think once again, it's a very delicate type of matter, trying to balance out those that is, and this is once again, the way this is now, the bill, and this is the way it came before you last year, and this is only for the most serious crimes. This would be murder, rape, sodomy, and the first degree. And but it's where that would now require there to be at least written notification within 7 days to the superintendent and or if it be a private school, then the headmaster, the principal at a private school. But it's where that'd be for the most serious offenses. However, if you go to the very last page, page 4, and this is where you really have the sensitivity to confidentiality. I don't want to take too much time of this committee, but if you want to go on that page 4, beginning with line 89 on page 4, it reads, any information received by a teacher, counselor, administrator, or other school employee. Well, first, that information, if we go back further in the bill, it can't be disseminated to those unless they are actively engaged with that student. For example, a teacher's wondering, well, what type of grade do I give this student that now has been put in alternative school, but they've not given me a reason, or even, know why. Well, first of all, the school officials may not know or whatever, but anyway, they've at least had that opportunity to make some decisions as to put them in an alternate setting, virtual or alternative school, and then also there'll be different ones of the school that would need to have that information as well, just for purposes of the ongoing operations of the school. So I think we have to balance that. You also have some situations and I just need to, of those that maybe, let's say it's a juvenile delinquent that has an ankle monitor for one of these very serious crimes and all, and now it's where the school officials under current then law, they've not been notified, and everyone's in amazement. And once that's discovered, they're wondering, and then you have then a little bit of some fright or fear, whether it be students and or faculty or whomever in regards to that. So trying to balance that is the rights of both of those, the one that's accused, the juvenile, and then those then that this is for a very serious crime, then that the appropriate officials need to be made aware of that. But anyway, going on back to the confidentiality, it says that this information shall be received in confidence and then only a limited purpose. It goes on to say of rehabilitating the child and protecting students and staff and shall not be further disseminated. So there's protections, somewhat I think, that's already a part of this, trying to preserve that confidentiality, the sensitivity to that. It goes on to state then on line 100, item C, an intentional violation of the confidentiality provisions of this section is a Class A misdemeanor. So I think there's things that's trying to really home in on what you're very concerned about. Likewise, I have concerns with that as well, but trying to balance both of these, I think this is trying to strike a healthy balance with this bill.
And have you spoken with the Judiciary Family Council? Or have you spoken with anyone from the Judiciary Family Guidelines or Juvenile Council or any
Yes, this actually.
juvenile?
Yeah. I would welcome those then. I mean, here, either Susie or either Judge Jordan, either one of y'all, either one. So I've checked with those with juvenile court, and that was one of the things that originally, the original bill was not then homing in just on the most serious offenses and all. And so that was one of the things that we did do. It's like, no, we need to make this so that would only, and that was, so under those conditions, then that did receive somewhat more of the, if you would call, so I'm not saying that they're taking sort of sides in the issue so much of something that they felt more comfortable with, and that would be that this be only for the most serious then crimes and going forward with that. So yes, I've been in contact. This goes back to last year's bill and such, and helping with the development of the bill.
Okay, and I've been in contact with our presiding judge with juvenile and family law, Judge Calvin Williamson. He did have the same concerns that I did with this.
Thank you.
Thank you.
Okay, ladies and gentlemen, there is a motion and a second to give House Bill 189 a favorable report. Are there any more questions or comments? Seeing none, all in favor, please say aye. Any opposed? Thank you.
Thank you so much, Mr. Chairman and members of the committee.
Thanks, Mr. Baker. We appreciate you a lot. Mr. Potter, I accidentally skipped over Senate Bill 30. I apologize. Are you going to carry that one?
Yes, sir.
Please.
Mr. Chairman, thank you, members. This is the exact same bill that we passed out of this committee, and it's.
Mr. Chairman, I make a motion for a favorable report.
And I see a second also. So there being a motion and a second for a favorable report, all in favor, please say aye. All right, thank you. Any opposed? All right, is anybody here? The next bill I've got is House Bill 26, which is Representative Butler. Originally, there was a request for a public hearing. No one signed up. Now, if there's anyone here to speak on that bill, I want to know. Otherwise, Mr. Butler, we are going to go forward and not have a public hearing and just go forward with your bill today. Is that fine? Yeah,
Awesome. Thank you, sir.
All right, seeing no one here wishing to speak on the bill, go right ahead, Mr. Butler.
Thank you, Judge and committee. This is the bill that we had last year that passed out of here, passed out of the House, and of course it never made it through the Senate. It's dealing with sex offenders, dealing with where the victim was a child, and it would authorize parole officers, probation officers, to restrict social media, phones, tablets, games, and the big thing, the big component is it would also allow the parole officer, probation officer, or the court so they can give sex offender treatment, which may include, but not limited to, periodic polygraph exams. The states that have passed this, which is a number, have seen a reduction in recidivism. And we worked with everybody last year with Aaliyah and Barnes and Parole to tweak the bill like they wanted, and everybody liked it.
Go ahead, Mr. Butler. I'm sorry, Mr. Butler.
Well, I'm hoping you guys will move for a favorable report.
A motion and a second for a favorable report. And you,
I have a quick question.
Sure, go ahead.
So I was reading over the bill, and on line 70, it says an adult sex offender subject to a sex offender treatment program or periodic polygraph examination. So is this an either-or situation where you either do polygraphs or sex offender treatment?
It's whatever the Barnes Parole or the court. This is not a shall, it's may. And it's not limited, if you're earlier in the bill, it says it's not limited to that. But it would put them in, they may put them in a sex offender treatment program. It's only when there's a child, and it may include periodic polygraph examinations.
Right, but I guess what I was saying is just that the wording is program or polygraph. So implying that you go one route or you go the other, not you can do both. And maybe I'm being a little nitpicky here, but then I also read where it says that if he or she is indigent. And so if they're indigent, does that mean that pardons and parole would pay for their polygraph, or would, who's going to pay for the polygraph exams?
The taxpayers. It would be, if the judge determines that, and he determines the amount, that's why we pay taxes.
Representative Robbins, if I may, maybe offer a point of clarity. I think Section C is simply dealing with the fact that they may be asked to pay for the treatment or pay for the polygraph unless they're indigent. It's more dealing with those things, the payment may be required. Because if you read up above, it does mention that they may use treatment or polygraph up above in the paragraph ahead.
Any other questions, comments? I will entertain a motion to give this bill a favorable report. Sir, ma'am. I'll be darned. Okay, good. There's been a motion and a second for a favorable report. Any other comments? All in favor say aye. Any opposed? Okay, Mr. Butler, thanks a lot.
Thank you, Mr. Chair and committee.
First time we've had anybody dodge a public hearing, so we may let you come back. I've got a couple, so let me come down there because I need to talk about it.
Hey, 228 has an amendment.
Okay.
Judge Hill,
Yes, sir.
you got HB 227. Would you explain the bill?
Yes, sir. Before I get to yes, sir, I will. On 227, Ms. Bates, did you ever get a? Nope, she didn't listen. She was working. You working on an amendment? We're going to carry it over. I'd like to carry over 227. There's an amendment. The amendment is going to be very friendly. Let me explain 227 to you for just a second, though. Okay. AOC. This is one of those agency bills that I carry from time to time, and AOC's run into a problem in that people have been donating monies, and I'm sure it's mostly attorneys and vendors and people of that nature, for the purpose of ensuring judicial education. And there's been some question raised about amounts, and there's going to be an amendment brought to specify after a certain amount disclosures will be made. I have no problem with that. And the reason that AOC feels like this is important is because our Department of Public Accountants simply said that the way they were doing it was improper, and they wanted it changed. They wanted it put into a nonprofit corporation to handle that part of the education. That's fine, but we will. Let's get the amendments because they're going to be friendly, and we'll carry them over. Let's carry this one over.
HB 227 is carried over.
Thanks.
You got HB 228.
Yes, sir, I
with
do.
an amendment.
Okay. Earlier today, we carried over HB 126 from Representative Brown because there was an agreement made on to add some language or an amendment to 228, which is the bill I'm going to talk with y'all about. This is an Anais law bill. Here's the essence of this bill is that an individual that is charged with one of these serious offenses for which bail is initially denied has a right to a hearing. That hearing must take place within 10 days. And then it went on and specified things. But let me talk to the amendment for a second because it clarifies that. On line 58, here's what it says. A defendant charged with an offense listed in subsection C, which is those serious crimes that we just talked about that are non-bondable, will be held without bail prior to a pretrial detention hearing unless the court is notified that there is an agreement between the parties regarding the conditions of bail. So what that amounts to, folks, is that the defense lawyer and the district attorney together entered into an agreement concerning the conditions of bail, then there would be no reason for a hearing. If they do not, there will be a hearing, and that hearing will be within 10 days. It'll be a pretrial hearing, and the pretrial detention hearing will be in lieu of the preliminary hearing. If you've ever done criminal work, you know in a criminal case, you always have a right to a preliminary hearing. This pretrial hearing would be in lieu of. It would be, because it would cover the same issues that the pretrial hearing or the preliminary hearing normally would do. Would take up, and in line 112, it just says up to 21 days following the arrest upon a determination for good cause. Just gives you a little bit more leeway to have that pre-hearing. What Mr. Brown was concerned about and what we're taking care of here is that these are all felony cases. Consequently, this is not something that's going to be taken up in your municipal courts. It's going to be taken up in district court, which is where felony cases are taken up. And this would give a pretrial, a pre-detention type hearing within 10 days on these serious offenses, unless the district attorney and the DA, the district attorney and the defense attorney agreed to those terms, and it would take the place of a preliminary hearing. So I would ask that you adopt I will offer the amendment and ask that you adopt it.
I've got a question. As far as you have to have the pretrial hearing within 10 days, but is that going to give the defense attorneys enough time to get discovery?
Yes, I think they will, because again, a preliminary hearing, as you know, is a probable cause hearing.
Most of the time, the defense attorney will file a motion for request production of documents, but then it's like 30 or 60 days before.
Must be done within 21 days, and it would be the burden would be on the prosecuting attorney to give the discovery that they had at that point. Now, let's say this, Mr. Wadsworth, that's a good question, but you have a preliminary hearing, and that preliminary hearing covers probable cause. That's all it covers. So at the end, at the next stage of a criminal case, as we know, is an indictment, and at that point, all discovery is due to be made. Yes, sir. I'm sorry. Mr. Tillman wishes to speak.
Yeah, go ahead. Go ahead, Mr. Tillman.
I was just going to respond because I know with the Anaya's law here, it normally typically happens within 72 hours of the arrest, and you don't have discovery at that point. And also in district court, you're not entitled to discovery. Right. So having and receiving discovery at that point, you're not entitled to it by the rules. So this right here kind of squares the peg of giving more time. So when you have the 10 days, you do have time to actually receive discovery at that particular point, which makes the Anaya's law hearing a better hearing, so you can have more discovery instead of having the prelim hearing subsequent to this.
Right. Thanks. I appreciate you.
Any other questions or comments?
I would ask we adopt it.
All in favor of, you need a second on the amendment. Second.
Thanks.
All in favor of approving the amendment, say aye. All opposed? The amendment's approved.
Then the bill is back to me as amended, and I would ask that you give this bill a favorable report as amended.
Oh, you got a second? Okay. All in favor, give the bill a favorable report, say aye.
Thank you. That's got it.
Bill gets favorable report.
Appreciate it. Good meeting. As usual, Chuck, it only took an hour and 15 minutes, but we had several we carried over, so we will try to make up for that lack of taking your time next week. Thank you.